Any industrial property right may be object of a temporary authorization to exploit it, granted by the owner to a third party. Such kind of authorization are usually called licenses. More specifically, for all the IP rights related to technology, design included, the more appropriate definition used is tech transfer, while for trademarks the term license is more common. The parties, licensor and licensee, may agree on the definition of various aspects related to the authorization granted. A first element is related to the choice of the territory. So a license may be granted for a group of countries, for a single country, or just for a part of a country. Of course, a license may only be granted for the IP-covered territories because in the non-covered territories anyone may exploit an IP right. A second element is that the license may be limited in time. A third element is related to the character of a license, which may be exclusive or not exclusive. An exclusive license is granted to only one subject, will be the only one allowed to use the trademark in a given territory. If the license is not exclusive, it may be granted to different subjects, all using the same trademark. For instance, I can grant a company an exclusive license to produce T-shirts with my trademark, or I can decide to grant a not exclusive license to 10 different companies, which will compete on the same market. Of course, an exclusive license is more valuable than a not exclusive one, but also a not exclusive one can, however, limit the competition to a few subjects. The exclusive license is more common for specific technologies, reputed trademarks or designs. At the opposite, patents on standard technologies like GSM or DVB-T, for example, are widely granted under a not exclusive basis. A license should normally be registered at the Patent and Trademark Office. If a trademark is then sold, the new owner will not be allowed to refuse to acknowledge the license. Also, the ownership of an IP right as a patent, a design or a trademark should be registered at the Patent and Trademark Office. If the IP right is fraudulently sold to more than one subject, the ownership goes to the one who registered first. What happens in case of infringement of an IP right which has been licensed? Who has the right to enforce it? In case of a supposed infringement of an IP right, a licensee cannot in general enforce the licensed IP right and start a legal action to stop the infringement. The so-called legitimation to enforce shall be expressly mentioned in the contract and it cannot be presumed. In order to avoid a problem that the licensor will not timely react in case of infringement related to a territory of an exclusive licensee, the Community Trademark Regulation provides a legal solution. In that specific situation, the exclusive licensee may enforce the European right if the owner of the IP right, after formal notice, does not himself start an infringement proceeding within an appropriate period. In the European Union, all the tech transfer and license agreements are subject to the antitrust regulation in order to avoid the risk of abuse of dominant position. In fact, an IP right claiming exclusive right may be easily considered as a monopoly, and any agreement related to it may be considered a cartel. For this reason, the Treaty of the Functioning of the European Union provides the possibility to adopt such agreements under certain conditions. In order to facilitate the adoption of general rules in drafting and negotiating such agreements, the European Parliament, under the support of the European Commission, adopted two kinds of regulations since 1995. The first kind of regulation is related to the tech transfer agreements. Such a regulation covers any agreement related to the technology rights, that means know-how, patent, design and software, or a combination thereof. The structure of the regulation provides clear indication about two kinds of prohibited contractual clauses, hardcore and exclusive restrictions. Hardcore restrictions consist in 4 prohibitions. Among them, the most relevant are to impose the price of the final goods and a restriction on the licensee to exploit its own technology rights, or the restriction of any of the parties to the agreement to carry out research and development. Any agreement comprising one or more of the hardcore restrictions shall be considered null and void in full. Excluded restrictions consist in 2 prohibitions. the obligation on the licensee to grant an exclusive license or to assign the right to the licensor in respect of its own improvement to the licensed technology, or any direct or indirect obligation on a party not to challenge the validity of intellectual property rights which other party holds in the EU. The only possibility accepted in the case of an exclusive license is to provide a clause for the termination of the agreement in the event that the licensee challenges the validity of any of the licensed technology rights. These dual restrictions may appear reasonable in a contractual intention to cooperate in a reciprocal way, but they are considered unfair from the competitive point of view. Any agreement comprising one or more of excluded restrictions shall be considered still valid, but the specific clauses will be considered not legally existing. The second kind of regulation is related to the vertical agreements. That means agreements between two or more parties, each one operating in a different level of the production or distribution chain. The regulation relates to the condition under which the parties may purchase, sell or resell certain goods or services. In particular, such issues are typically involved in trademarks agreement like merchandising, franchising, selective distribution agreements. Like before, two kinds of prohibited contractual clauses exist: hardcore and excluded restrictions. Let's examine these restrictions. The hardcore restrictions consist in 5 prohibitions. Among them, the most relevant is the prohibition to impose the price of the final goods. It's only possible to advertise a recommended sale price. Excluded restrictions consist in 3 prohibitions. Among them, the most relevant is the prohibition to impose any non-competition obligation exceeding 5 years. Each of such regulations are supported by specific guidelines published by the EC Commission. As you may clearly understand, drafting a tech transfer or license agreement cannot be reasonably left to the mere commercial wishes of the parties, but it should be carefully evaluated by a specialized lawyer supporting the parties. The risk otherwise will be to draft a partially or fully null and void contract in the best of the option. In the worst scenario, the behavior expressed in the contract may expose one or both parties to very significant economic fines from the antitrust authorities.